Sam Seder, Emma Vigeland on the Majority Report. Want to welcome to the program Dylan Penningroth, professor of law and history at the University of California, Berkeley, author of Before the Movement, The Hidden History of Black Civil Rights. Professor, welcome to the program.
Thanks so much for having me on.
So let's start with, I guess, the genesis of your doing this really, a decade long, more, I think, of research into these documents and essentially recreating the way that recently freedmen and slaves would interact with our society through its legal channels. But let's start with your great aunt and uncle, maybe three greats. I'm not quite sure, which led you to sort of, I guess, begin the interest in this.
Absolutely. So when I was growing up, I used to hear family stories at reunions, cookouts, things like that. And one day I got my hands on a recording of my great uncle, Thomas Holcomb, who was talking about his father, Jackson Holcomb. And one of the stories that he tells on that cassette tape, it's one of these old Memorex tapes, is of when his father gave a boat ride to a bunch of Confederate soldiers in the closing days of the Civil War, about 1865, across a river that they needed to cross. And in the story, he mentions something that's really curious to me, which is that when they got to the other side of the Appomattox River, the soldiers got out and they paid him. And that seems to be a really strange thing to do, because after all, Jackson Holcomb was a slave, and the soldiers really had no legal reason to pay him. And of course, they had all the guns and every reason to be angry about losing a war over slavery. And yet they paid him apparently without asking any questions. And that really got me thinking about, why would white men in 1865 be so, why would they think of paying an enslaved man for services so casually, almost matter-of-factly, almost as if this enslaved man had contract rights? And one of the things that I came to realize over the years is that contract rights are one of the fundamental rights that fall in the category civil rights. And so we can talk more about what civil rights are, but the first thing I just want to sort of lay down is that civil rights in 1865 are not quite the same thing that we mean by civil rights today.
I was even stunned that, both that they're paying a slave and a black man, but I was just stunned that they were paying anybody at that point, to be honest with you. Particularly in retreat, it's not like you're going back the other way. And so I was surprised by that. Just like in a general sense, before we get into specifically like how this set of rights and access to the law was available to a group of people that we wouldn't have anticipated would be available. But what were the, like, why was that so sacrosanct that they were compelled to pay in that instance?
I think it goes to a really fundamental question that is looming back up in front of us very much over the past few years, and that is a question about the rule of law. So, you can think about the rule of law as this kind of abstract thing that hovers over society. You can think that we often assume that it's this very strong, sturdy set of ironclad laws. But in fact, the rule of law is a set of expectations that all of us hold about essentially the way things work in the world. And when the rule of law gets torn and there are no consequences, things can go south in a hurry. So one of the moments when the rule of law often comes close to getting torn is during wartime. And so during the Civil War, you see both on the part of Union soldiers and Confederate soldiers, this, I won't say it's that they're always doing it, but there is this really incredible attention to the rule of law in the following sense. When they take property for use by the army, they give receipts they keep track of it. And in fact, the Northern Army that leads to a congressional commission that is aimed at compensating loyal Southerners for property that they lost during the Civil War. And I think that's the same set of motivations that leads these Southern soldiers to observe, essentially, it's not that they think Jackson Holcomb has a right to be paid. It's that there is this sense that people have an expectation to be paid for services, including slaves. So this is coming out of a world that I describe in the early chapters of the book, where enslaved people have privileges to earn money and get paid for it. And so the soldiers are essentially recognizing this world, not so much as a set of rights, but a set of expectations that everyone is a part of. And if they tear that set of expectations, things can get really bad for everyone.
Was this a function, because essentially you're going from 1864 to 1970 in this examination of how these rights, how Black people basically experience these rights. But do you think a function of, I guess it reminds me of part of the whole sort of civil rights era was, in part at least, a function of the U.S. competition with the Soviet Union, where there was this pressure where we needed to show, third world countries, non-aligned countries, that we were, providing rights for all our citizens as a way of basically selling ourselves. Was that what was going on? I mean, is that why these type of like personal interactions on some level were upheld, because there was a sense of like half the country, regardless of whether I'm from the Union or the Confederate, is against us, and we need to show that we're a little bit above, that we're better. You're going to be able to prosper, and the only way you're going to be able to do that in the context of this country is if we have some measure of upholding these type of like personal exchanges.
I think the larger question, the larger point that you're making is absolutely correct. Although in 1864, they're not really worried about what other countries are thinking about them so much.
Well, no, I meant within like the competition. I'm using that as an analogy.
Oh, I
U.S.
see.
and Russia competing with each other, it's bringing out their better angels. And I wonder if that wasn't the case too with the Union and Confederate when they had to have these type of transactions.
I think that might have gone into it a little bit. I think that what mattered more to these folks is that they're thinking of local neighborhood understandings about property. So I'll just take an example that I think all of us can, or many of us can relate to. If you have a home mortgage, that mortgage, it records. It depends on a series of transactions that come down from property owners before you. So when you buy the property, you have to take out title insurance from Chicago Title or something like that. And what they do is they send people to the courthouse to look up the chain of title. And what they want to find is a clean, unbroken chain going from the first owner down to you. If they find a break in the chain of title, then you've got problems, because then the property is at risk of someone else showing up and saying, I actually have the rights to this. It'll be expensive to defend. Someone will have to go to court. That's what title insurance is for. And so it's that set of understandings that I think people are really keenly attuned to. And as I said, these understandings have everything to do with civil rights. So when I talk about civil rights, I'm talking about property, contract, and the right to sue and be sued. Now, Jackson Holcomb didn't have civil rights, but what he had was privileges. He had the privilege to earn money. He had the privilege to make deals, bargains. But in the event, in practice, what he and many other enslaved people found was that these privileges were so widely respected, not always, but they were widely enough respected that you can see that they're following the same logic that rights do, the rights that white people have. And so one of the things that I argue in the book is that in 1865, when Black people become free, and in 1866, when you get America's first Civil Rights Act, the Civil Rights Act of 1866, which says that all persons born or naturalized in the United States have the same right as white persons to own property, make contracts, and sue and be sued, that's actually not a huge break from the slavery period. Like, it's really easy to think that slavery is the absolute opposite of freedom, right? And that, in a sense, is what so much of our politics is built on, this idea that a slave is the absolute opposite of a free person. In some senses, that's right when it comes to political rights or so-called social rights, which we can talk about in a minute. But when it comes to civil rights, the actual practice that white people and Black people in the South experienced in their everyday life, when it comes to things like paying for being ferried across a river, or paying for chickens or eggs, paying for brooms, things that enslaved people make sort of on the margins of society, selling them in the town square. White people are used to dealing with slaves on that basis. They're used to seeing slaves essentially owning things like pigs and exercising rights over chickens and boats and things like that. And so in that sense, 1865-66 is not such a sharp break. And once we start to think of it that way, it starts to give, I think, a different perspective on the conservative Supreme Court majority's views about things like race and rights.
Well, what does it tell? I mean, I want to come back to that question as to what does it tell us about that. But give us a sense of the kind of research that you did do, so that people understand what was uncovered here. Because I think, looking back, it is hard to have imagined, at least in that era, anyways, that there was the opportunity for Black people to access the courts, even.
Sure. No, this book took a little while, as you mentioned a bit ago. And part of the reason it took so long is that one of the key types of sources I used was court records from county courthouses. So these are not digitized. They're not online. Most of them are handwritten, and they're out in county courthouses. And so what I would do is I would hop in my rental car and I would drive out to Holly Springs, Mississippi, or Jackson, Mississippi, and I would go downtown to the county square, and I would walk past the big Confederate statue that stands outside of every county courthouse in the South, even today. And I would go inside and I would ask to see old court documents. And so I used two kinds. One was these big cloth-bound, leather-bound ledgers. They weigh about 10 pounds each. And I would take down names of people in lawsuits. And I was looking mostly at civil suits. And once I got the names, I would go back, and my research assistants and I would look up the names in the census to try to figure out which of these names was Black. So here's a funny thing at the beginning. These local court records, surprisingly, do not flag race. They don't say Dylan Penningroth, Negro. Nowhere does it say that on these court documents. And that in itself is a really interesting question. Why not? But in practical terms, what it meant is that we had to take this extra step in order to do this research. We had to figure out which of these cases involved Black people. By the end, we'd collected 14,000 cases. And of those, we found about 1,500 that involved Black people, either as plaintiffs or defendants. And in almost all of those 1,500 cases, there was no clue that the people involved were Black. Then I went back to the courthouse and I looked and I asked for the loose papers. So behind those leather-bound documents, there is often a folder or a set of bound up papers wrapped in red tape, literally red tape. And I would unfold it and I would read the testimony, if there was any. And from that, I begin to piece together a story of how African Americans are engaging with law, thinking about law, talking about law, all the way back to 1872, going forward to the late 1960s.
And so you talk about like the sort of the conception of rights, the civil rights, social rights, political rights under the law, and also you describe that ultimately the way that Black people are engaging with the law at this era and going forward ends up setting up a sort of like, I guess, a pursuit of prescriptive rights on some level. Is that right? And explain what that means.
So prescriptive rights are this broad category of rights in modern law, and they go back a long ways, that essentially say that actions that may not be legal can confer rights over time. So the classic example is your neighbor cuts across your backyard and you don't say anything. If that happens for long enough, and it's set differently in each state, but say 7 years, then your neighbor could actually say that he has rights to cut through your backyard.
There's been an easement created in a sort of de facto way.
You'd have a constructive easement. So these prescriptive rights can ripen over time into legal rights. You can actually turn trespassing into something legal. Now, there are all sorts of rules hedging it in. It doesn't happen very often, but the principle at the bottom of it is the one that I pick up and run with, which is that enslaved people are exercising prerogatives that are not legal rights, but they're so widely recognized and respected that they're part of the same logic that is at work in the doctrine of adverse possession, which is what I just described with cutting through your neighbor's backyard.
So what were those activities? And we have that in the context of property law, right? Like, squatters or squatting rights. And that's why, people are making a big deal of it now, but this is something that has existed in law, I think, even, prior to, this was English common law, I think it was, that sort of established this concept of squatting rights, just broadly speaking. But what were those things, those actions that were being taken care of? Was it simply exercising their sort of contractual and almost, I don't know, what you would call that, commercial rights that ended up sort of expanding on some level?
Well, I think what I can say is that enslaved people's, when they're acquiring chickens, when they're growing vegetables in their back gardens, we're seeing them engage in economic activities. And there's two things that I think are key takeaways from that. One is that the masters are essentially shifting the costs of sustaining the slaves, like part of the cost of doing business, onto the slaves. So you always have to remember that a plantation is a profit-making business. Southerners like to describe it as, moonlight and magnolias. We're all one big happy family. But these are essentially capitalist enterprises. They're trying to make money. And one of the ways that masters made money was by cutting down on their operating costs. And they did that often by shifting the costs of feeding and clothing the slaves onto the slaves themselves. So the slaves, they have the quote unquote privilege of working for themselves after hours. Now, keep in mind that after hours is after sundown. So they've been working from sun up to sundown. And then they have the privilege of doing things like keeping pigs and chickens and selling them. And with the proceeds from those earnings, they feed themselves things that the master doesn't provide. So that means that the master can now give, 6 pounds of fat pork and, a bunch of cornmeal, which on its own would be starvation. There's not enough nutrients in all that. But the master can do that because he knows that the enslaved people are going to get their vegetables through their own efforts. And so there are a lot of ways that this takes place. Elder care, masters shift the burdens of old age onto enslaved people. Medical care, same thing. And it's all done by exploiting this system of prescriptive rights that the slaves participate in. And again, this is sort of this larger set of understandings that helps explain why the soldiers paid Jackson Holcomb after he took them across the river. It's part of the same set of understandings. And if they didn't pay him, of course, they had the power not to pay him. They had the right not to pay him. But if they hadn't, they would have had to sort of upset that mental universe in which it is normal and expected to pay even an enslaved person for services performed.
How conscious were people at that time, do you think, of like, this is, I mean, on some level, you're talking about like social reproduction and so that the slaves could be available to work, you know, increasingly for even less than free, right? At that point. How conscious was everybody in the South that this is, you know, when we pay this slave for ferrying us over, we are in some fashion supporting our broader system. Like this, like if we were to deny them, it would ultimately end up like undermining the plantation system.
It's hard to say how conscious ordinary people were. I think that things like this largely sort of, they go unconsciously.
Just become custom.
Custom. It's part of the water that you swim in. But there are moments when people kind of snap to attention. And those moments tend to be when a group of white people who feel aggrieved by the privileges that slaves have, they agitate in the state legislature to get a law passed. They essentially say things like, well, you know, we're mechanics, we're taxi drivers, and we are aggrieved, and we think there ought to be a law. There ought to be a law against enslaved people working as mechanics or as taxi drivers. And so they get a law passed, and then it goes up to the court, the state Supreme Court, and the court once in a while will articulate openly that logic that we've been talking about. You know, and the court will say things like, well, everybody knows that in spite of the law saying that slaves can't do X, Y, and Z, everybody knows that slaves do it anyway. And everybody knows that this is part of the system, part of the set of understandings that makes our system work.
Interesting. And so then we have this, I mean, that dynamic, I would imagine, keeps playing out over and over again, because on one hand, you got to give slaves and even freedmen at that point who are going to come back and work on these farms in many respects through Reconstruction, the ability to support working at such low wages. I mean, we see that in the context of, Walmart relying on the government to provide Medicare on some level. This is some iteration of that. But then the rights or customs that are afforded to these freed black men they start to actually accrue wealth in some instances. I mean, you write about going from 1870 to 1910, home ownership goes from 43,000 to 500,000 over that time. You've got a similar sort of like other measures of property ownership. You talk about your great uncle and aunt, amassing a little bit of a tiny fortune, I guess, relatively speaking. And then, of course, we get this huge societal blowback in the form of a reemerged KKK in the 1910s and so on. But how does that play out legally? I mean, they go and they pass these laws. I would imagine that's where some like licensing laws came from and other things like that to exclude, to both allow, on one hand, you want to allow a certain amount of commerce in that, but then you also don't want them to like make that much money, assuming you're these people.
No, it's absolutely true. One of the fascinating things about this story is that um, the racial violence, the lynching that you mentioned, the KKK, it's actually it is growing and peaking at the same time as this rise in Black wealth. So the high point of Black land ownership, 15 million acres around sometime between 1910 and 1920. That is around the same time as the peak of lynching in the United States, the greatest number of Black people lynched. So these are actually happening at the same time.
Non-coincidentally, right? I mean, that's what the Tulsa massacre was about. I mean, that's what all of these massacres that happen in towards the end of Reconstruction is. This is blowback essentially from I think what Carol Anderson wrote, like white rage, 2 steps forward, 1 step back type of situation.
It is blowback, and at the same time, the blowback does not succeed, and I think is not designed to succeed in driving Black people into utter poverty. They never stamp out this Black middle class, and I think there are a lot of different reasons for that. But I think that one reason is that they don't need to. There are plenty of ways for wealthy white people to stay on top of the South's economic system other than eradicating a Black middle class. But another reason is that the rules of property and contract, they don't formally take race into account. So that chain of title that we were talking about earlier, nowhere in the chain of title does it typically say that this person was a Negro. And that's because property law doesn't have separate categories for white and Black people. It's just property law. And there are reasons for that within property law. Essentially comes down to property law is really conservative. It's hard to change. But another reason it's just really inefficient. Where would you put a ledger? Where would you put a transaction from a white person to a Black person? Should that go in the colored property or the white property? It right. Just becomes administratively a nightmare. So there are all sorts of reasons why white people don't completely deprive Black people of their property and their contract rights. But one of the biggest ones, I think, goes back to this, the same dynamic that we saw during slavery, which is that you don't need it. You don't need to deprive Black people completely of property in order for the system to work. And by the system, I mean a system that keeps most white people, along with most Black people, quite poor, and a small cadre of wealthy white people at the top. The system functions during freedom as well as in slavery. So I'll just give you a quick example that comes again from a different side of my family, which is in 1866, I found a contract dated 1866. I think it was June 30th, 1866, where a white man named William R. Baskerville signs a contract with, I guess, 30 or so Negroes formerly his slaves, right? So these are people who used to be his slaves. And one of the things that the contract says is each of these and formerly enslaved people is going to get a certain amount of corn at the end of the year. And they're going to perform certain jobs, but it doesn't go into great detail. The contract doesn't say much about what those jobs are. Instead, it says that they will perform the work as they have heretofore done while they were slaves. So there's this contract that's literally saying that these people are going to work like slaves, but because they're getting this contract, they are by definition, and by modern definitions that even John Roberts would understand, they are free because they have the right to make this contract, because they are going to be paid for services rendered. So the system functions to keep men like William R. Baskerville on top, and people like Rosa Baskerville, who I think is another one of my ancestors, although I can't trace it exactly. It serves to keep people like her poor. And it's done not in defiance of the law. This is not an instance where William R. Baskerville is running around with guns and whips and terrorizing Black people. It's working through the law. She's signing because she doesn't have any better options. She can either sign this contract or she can starve. And so this is the dynamic that keeps most Black people, and most white people for that matter, on the bottom economically. And it serves very well, even without violence, to keep the white elite on top.